Good afternoon to everyone present at today's public hearing of the Vetting Commission, established under Law Number 65 on the external evaluation of judges and candidates for the position of Judge of the Supreme Court of Justice. I am Andrei Bivol, Chair of the Panel A of the Commission, and I declare this session open. This hearing is being conducted under Law 252 on the external evaluation of judges and prosecutors and amendments of some regulatory acts and under the Commission's rules of organization and functioning. The subject of today's hearing is Angela Braga, a judge at the Central Court of Appeal. Judge Braga, welcome. I'm joined by the two other members of the panel. On my right is the national member Lilian Enciu, and on my left, the international member Lavly Perling. Also present today is a photographer who will be briefly taking photographs at the beginning of the hearing. The hearing will be conducted with interpretation between Romanian and English. To allow for accurate interpretation, I ask everyone to speak clearly and slowly. The recordings of the public hearings will generally be available online on the Commission's website within 3 days after the hearing. During the hearing, one or more members of the panel may ask you questions with regard to the doubts identified. Your explanations are important to the panel in verifying your financial and ethical integrity. At the end of the hearing, you will be given an opportunity to make a brief closing statement. In posing questions, we will consider your privacy and, where required and possible, the privacy of your family members and close persons. So we will leave out unnecessary details related to ID numbers, bank account numbers, addresses of real estate, and so on. And we ask you to do the same in order to protect your privacy, with the exception of the situation where it is needed to clarify some circumstances. I will start by briefly reviewing the evaluation process of Judge Braga. The Commission initiated the evaluation on 11 April 2024 by notifying Mrs. Braga by email and asking her to complete and return an ethics questionnaire and the declarations required under Law 252. Mrs. Braga returned the completed declarations and questionnaire on 30 April 2024. As part of the evaluation of a subject's ethical and financial integrity, the Commission also obtained information from many other sources, such as the National Integrity Authority, the State Tax Service, the General Inspectorate of Border Police, and other public institutions, as well as financial institutions and open sources. The Commission assesses the information it obtains for its relevance and reliability. On the 27th of September 2024, 18 December 2024, the Commission actually sent to Judge Braga 3 rounds of questions. Judge Braga reported back with this information. On 24 January 2025, the Commission informed Madam Braga about the doubts identified, which would be discussed during the hearing. At the same time, we sent her the invitation to today's hearing. On 30 January 2024, Madam Braga sent additional explanation with regard to the doubts identified. On 31 January 2025, Madam Braga also sent additional information, an additional statement on behalf of Mr. Ciubuc, and an agreement with regard to collateral understandings. Madam Judge, would you like to rectify the information that you provided so far? I don't have anything else to declare. If I'm not mistaken, there is also an agreement with regard to sale and purchase between Andrei Ciubuc and the other person. It's a contract related to a sale of a vehicle. Thank you very much. Would you like to rectify or add anything related to the ethics questionnaire and the declarations? Only the additions that I will make further on. Going forward, the members of the panel will ask you additional questions with regards to the doubts in question. In the hearing notice, we communicated to you some doubts. Those are pertaining to ethics and financial integrity on the parts of ethical issues. The doubts concern inexplicable wealth, which is expressed by a negative difference between income and expenses. So based on preliminary calculations, this difference in the evaluation period resulted in a negative balance of 239,192 lei. This negative balance has been identified in various years. We've got a negative saldo of 151,791, and later in the other years, in 2021, another negative balance, in 22 a negative balance of 51,065 lei, and in 2023 a negative balance of 12,839 lei. Going forward, we'll discuss each year specifically, and we'll begin with the year of 2014, where your family received a loan, actually, in the amount of 250,000 lei in order to refurbish your apartment from Cuzăvoda Street. In your information, you said that out of the amount of 250,000 lei, only 50,000 were used actually in order to refurbish the apartment. However, from the information received from the bank, it is clear that there are receipts with regard to repair works in the amount of 194,729 lei. Could you please explain the difference between these amounts and give us a clear-cut answer with regard to the expenses made for this refurbishment and how the difference of those money were used? I have presented additionally, and I also maintain that the amount of 250,000 lei and 194,000 lei have not used only for refurbishment. We intended to carry out an expensive refurbishment. However, when my application has been accepted and following, and when we actually wanted to buy an apartment with a preferential price, we understood that there is no need for us to invest lots of money in the apartment in Cuzăvoda. Therefore, we tried to invest those money in the apartment from Cheucar. We did actually the basic things, the basic works. We focused on the bathroom. Other than that, we thought that the conditions were pretty much okay. We presented the receipts of the bank, and we remembered about that when, following the second round of questions, we obtained these receipts from the bank because, actually, we forgot about them. It was a period, in 2015, we presented those receipts and we forgot them. Therefore, my husband, as I explained, we gathered actually together all the receipts from relatives, acquaintances, including from 2 acquaintances that were involved in the repairs, and they actually kept those receipts, and we presented those receipts to the bank in order to be on good terms with the bank. They cannot be attributed to us, and I have mentioned that, and we identified in those receipts some exchange currency transactions. There are receipts confirming the payment for a loan. So we did something. We gathered everything we could in order to reach out this amount that could be confirmed to the bank. Therefore, a great amount of to a great extent, many of these receipts, if, for example, if the loan has been contracted in August 2014, the receipts are actually dated within half a year, but also there are receipts from 2013. I do understand it's much convenient, it's more convenient to take this evidence, but it's not a very credible amount that was used for the repairs and refurbishment. If we were to accept your versions, that means that you presented false, erroneous information to the bank. I am very sorry about that, but indeed this is the case. That was the best option that we could do back then, because we didn't spend those money, because what we intended to do was to invest those money in the apartment in Enciu Court, and that happened immediately after we got that loan from the bank, because we thought that the bank will oppose to that once we do our investments, and you can have issues with repaying the loan. And I understand, so if you had presented to the bank only information with regard to 50,000 lei, you would, I'm not aware about our risk, but I think back then that was the proper thing to do. We thought that the bank might ask for a urgent repayment of loan, and therefore we thought necessary to take that approach back then. But ultimately, the bank was not affected by our behavior. Now let's talk about the 2018, where your husband bought actually a vehicle of Toyota Auris, model year 28. He bought it for 30,000 lei. Based on the receipts of the customs service, this vehicle has been introduced in the country on 11 April 2018 and was valued for 1,000 lei. And there are taxes paid for this vehicle, and the total imported value of this vehicle amounts to 122,675 lei. How would you explain this significant difference between the price, between the value of the imported vehicle of 122,000 and the acquisition price declared in the agreement of 30,000 lei? I can only talk about the acquisition price. With regard to the import of this vehicle, I can only presume. It wasn't us who bought this vehicle. It was bought from a parking lot, because we tried to find who was the person who imported that vehicle, but that was impossible, actually. That person is not working anymore in that parking lot. It was hard to trace him back in order to identify the right amount of money. I presume that was an inconvenience with the customs service when the price has been declared. We know that customs do not always accept the price of the import only based on transaction, but in many cases the value of the imported good asset is established based on similar transactions, or I don't know, other cases. There are many litigations, pending litigations related to this sort of issues, because sometimes the custom does not accept the value declared by the importer and sets out, or at least the person who imports the asset needs to declare the value which is being proposed by the customs. Value which is assessed by the transactions carried out previous to that date, or based on the vehicle, on the same type of vehicles. I can only presume that, but what I can tell you for sure, we didn't have a greater amount of money at that time. We also presented the collateral agreement, and you saw that the amount was established for this vehicle in the amount of 36,700 lei, and that was set out immediately when the vehicle was bought. I do have some additional questions then. What you're trying to say is that 30,000 lei was the real price of the vehicle. That was the real price paid by us. And the value of the collateral agreement for the loan you took from Agroinvest was related with the vehicle or the loan you wanted to have. It was related to the value of automobile, not our needs. And the value of the asset which was taking as collateral wasn't supposed to be higher. How could you explain that the next year, if the vehicle cost 30,000, your husband next year tried to sell this vehicle for 6,999 euro? It was a price which was required for this vehicle, but in the end, the price for this vehicle was only 50,000 lei. I don't know what was the reason for that, actually. I cannot tell you why this exact amount has been required for that car, but for sure it wasn't sold for that price. You can ask any type of money for a specific car, but in the end it's not necessarily happens. Let's discuss about the year of 2021. In 2021, your family has acquired a Skoda Octavia vehicle manufactured in 2016 for a contractual price of 80,000 lei. Again, based on the receipts from customs service, this vehicle has been imported by a tertiary person in December 2019 with some technical deficiencies at the front bumper, and the vehicle has been estimated at 180,000 lei, and there was also some taxes paid related to this vehicle. And overall, this vehicle was estimated at the amount of 180,074. How could you explain that this very vehicle has been bought by your family with 80,000 lei, 50% less than today's price? That was the price actually asked by the seller. I explained that my husband identified, actually he saw that vehicle at a technical repair shops, and the owner of that repair shop said that you need to invest additional money in this vehicle, and he's not willing to do that, and that's why my husband decided to pay this price to buy this vehicle. We invested some money in it, but not too much. In 2024, your husband actually tried to sell this vehicle. What was the price asked for that vehicle? I don't remember. I know that he ultimately sold it. For what price? For 150,000 lei. That means 70,000 lei more than the price paid initially in 2019, right? That's correct. How would you explain that the value of this vehicle increased with 70,000 once it got older? With regard to vehicles, I cannot tell you very much. I'm not very familiar with this industry, because I also did some research while I had to report to you about these vehicles. I'm not very familiar with this very topic. I always listen to my husband with regards to vehicles, because I personally, I don't drive vehicles personally, and if he tells me that, for example, he found a vehicle that is suitable for our family, then we decide to buy it. Other than that, he's the one responsible with these issues. Now let's talk about 2022. In 2022, the Commission has established a total amount, the overall amount of expenses at around 194,208 lei. You said that this amount should be decreased till 125,982 lei. Could you please explain how did you reach out the decision to have this amount when it comes to expenses for 2022? We based our decision based on the transactions that we carried out, because the majority of expenses, the utilities we paid, the groceries we spent money for, the household expenses were paid by debit card or credit card, and namely this amount has been established by our expenses with our card. Therefore, we have reached the conclusion that these were our expenses. Other than that, we cannot say that we didn't spend more than we had. So your explanation would be that your expenses have been exclusively the expenses which appear in the bank statements. We might have used our money, and because my husband also had his salary. And please take into account that vacation expenses are not included here. The vacation expenses are included in 2020. For example, in that very year, we've got 20,000 lei allocated for vacation expenses. And the National Statistics Bureau can confirm that the expenses for vacation are being included in CCP. Though this is the explanation. I understand that could be very hard to believe, but this is the case. Now let's discuss about vacation once you touched upon it. You said that out of those 20,000 lei spent for vacation in 22, 10,000 would have been covered by your parents. Could you please tell us why those 10,000 lei are not included in the declaration of assets for 2022? I have not included that, and I know that I did not include any donations. As far as I know, we don't need to put this information in the declaration of assets because they don't exceed a specific amount of money. But when it comes to the declaration to the Commission, I cannot provide evidence other than the statement of the parents that, in my opinion, could be accepted as critical because they are our parents. Therefore, we did not include this amount. But you can see that in that very year we had an anniversary, and we actually did not through out a celebration, but we decided to went on a vacation. I don't like to say that I receive presents and gifts, but we know what are the traditions in Republic of Moldova to this sort of anniversaries.
So it was your mission. Yes, I could say that it was an omission on my side, but it was because you cannot provide evidence on that. Let's clarify another aspect from 2023 regarding the statements made to the Commission. In the first round of question, you declared that your cash savings at the end of 2023 were 100,000 lei. After that, you said that that amount should have included bank savings as well, the amount in the bank, the amount that you had at the bank, and you were not aware of that fact at the beginning, and you asked the Commission to exclude the bank savings of 36,699 lei from year 2023. How do you explain this, and what is your final say in this? what was the amount of cash savings and bank savings. You know, our family doesn't necessarily have this strict record keeping how much money we have on 1st of January or on 31st of December. I included the amount of the savings, and it happened in October 2024. I didn't know what was the strict amount. I knew that we had an average of 100,000. I made an estimate of the expenses, of the income, and as a result, I came to the conclusion of this amount. When I looked at the bank statements, I saw that in January, several amounts have been withdrawn, so they were kept at home, and a part of them have been spent. I'd like to say again, all the savings have been declared with approximation, because I cannot tell you very strict, concrete numbers. We don't have this rigorous record keeping. Perhaps it would be good to have it, but it is what it is. This is our situation. I didn't know the exact amount, and I provided you with an approximate amount. Thank you. Next, we have several aspects to discuss regarding ethical integrity, regarding the non-declaration of certain goods and assets. The first case, such case of non-declaration, is related to the declaration submitted to NIA in 2016. The salary of your husband, 6,411 lei from Vlaton Trans LLC. Could you please tell us, explain why you did not declare this? I identified this non-declaration when I received the questions from the Commission. My husband worked at two companies simultaneously, and perhaps this is why, this is the reason for not providing the information for one of the companies. It was not intentional. It was not with bad intent. You did not declare the 2,813 lei from the Chișinău Court, the salary. It was in 2020, sorry, in 2019. No premiums have been paid back then, and I was on maternity leave and transferred to the Court of Appeal, and this money was wired into my account. And when I came back from maternity leave, I made a declaration for 2 years and several months. And unfortunately, I have omitted this amount indeed. The third case, in 2021, your husband took a non-bank credit of 26,000 lei from UT Credit. It was not included in your annual declaration submitted on 30 September 2022, in which you had the obligation to declare everything for 2021. Could you please explain how you made this omission? I want to clarify that it was not a credit. It was not a loan. A phone was bought with this money. Sorry, a real estate. A real estate was bought, and installments have been paid for this. I know that my husband paid for it, and I assume that he... So he bought a phone in installments. I wasn't aware that he didn't pay the full amount. But we did not receive this money. Our incoming financial flows did not increase. Make me understand. You perceived this contract as a sales purchase contract, not a loan. Yes, this is what it was. He bought a phone, and then he paid for it in installments. And the last thing regarding non-declaration and doubts related actually to non-declaration. With reference to the fact that your husband has an account on the 999.md platform, and his phone number is actually listed there, and some announcements were posted by him, announcements of sale of several cars. So, on 20 March 2022, an announcement was posted on your husband's 999.md account regarding the sale of a Ford Fusion vehicle, year of manufacture 2019. Later, on 3 May 2022, another post was made regarding the sale of a Ford Fusion, year of manufacture unknown. From the photos and the post descriptions, it appears to be the same vehicle. Can you confirm or deny this? I don't know, and my husband wasn't able to explain. We suppose it was the same vehicle. We tried to learn who is the owner of this vehicle, but we were not able to do so. We suppose that this announcement was posted by someone who doesn't work anymore or doesn't have an account anymore. We were not able to identify whose vehicle it was. I identified the owner of the car, actually, and I have presented you with the contract. We did not reach the issue regarding the Honda vehicle, but a question. If I understand your answers correctly, this account on 999 is used by other people as well? Yes, it is used by my husband's colleagues at work. Not very often. My husband usually uses it, but his colleagues as well use it sometimes. Regarding Honda Accord, you identified the owner of this vehicle. Did your husband facilitate this transaction, intermediate it? No. So the owner is a colleague of my husband's, and I presented you with the contract.
Okay, înțeleg că dacă alte persoane au acces direct
So other people have direct access to this account, or your husband posts announcements on their request. I did not clarify this. I never made announcements, but he said that this account is open on his work PC. There are around 10 colleagues, perhaps, in that office, and there were no situations where your husband facilitated or perceived a fee or took a fee for this. No, for sure. Madam Braga, thank you. The Commission exhausted all the questions it had.
Vă propunem să faceți o scurtă declarație de sfârșit.
If you want, you can make a brief statement before we conclude the hearing. Yes. If I may, I'd like to say that the vetting procedure is a very complex process. For me, it was like an exam, and all the exams I took in my life were overshadowed by this one. I want to tell you that it was and it will be a difficult period of time for me since I received the notice of hearing and the notices in general regarding this evaluation. It was difficult for me because for me and my colleague, it's difficult to provide all these answers. It takes a lot of time. I recalled a lot of events that happened in my family over these 12 years and even more. I learned more about bank accounts, cars. Very interesting experience indeed. I wish for the vetting process to be an exceptional process as provided in Law 252. And I hope that the Commission and the subjects will do their best. I did not violate conduct rules. I try to do my best for the decisions issued to be in line with the law. I always declared my assets and the assets of my family. I paid my taxes. And I'd like for the Commission to take this into account. I wish you best of luck in the work you do, because this is hard work and very responsible work. Thank you very much, Madam Judge Braga. We have come to the end of today's hearing. Thank you for participation and for the information provided and answers to the questions during the hearing and during the evaluation process. After the hearing, the panel will approve an evaluation report stating its conclusions as to whether the subject meets the criteria for ethical and financial integrity. The report will be approved and issued as soon as possible. Thank you very much, everyone, and I declare this hearing closed.